Appeal court for Abuja today don sack another PDP governor, declare APC candidate as the governor of Plateau State. No be small thing. Make we hear from wetin PDP lawyer to the governor wey dey sack, wetin im talk for the matter. Make una no forget to like, share the video so that Facebook fit recommend am give other people.
The third respondent, that's the PDP. The judgment was not unexpected because we've seen the line of decisions of this particular panel. It should be noted that Plateau State is the only state where a dedicated panel was made available for all their appeals. In other jurisdictions, in other states, panels are set up for individual appeals, but in respect of Plateau State, this panel was set up and they are trying all the appeals. They are hearing all the appeals from Plateau State, which of course raises an issue of whether this is in line with the procedure adopted by the court. Another issue we find wrong with the judgment is that the lower tribunal, the trial tribunal, actually dealt with a petition that raised issue of invalidity of nomination and sponsorship of second respondent, that's the governor of Plateau State. But on appeal, and they found that his nomination was valid. On appeal, the appellants actually formulated grounds that restricted themselves to the issue of sponsorship. And we raised the issue that what is being had in this court is different from what the tribunal had. The tribunal had a case of nomination and sponsorship and made a finding on it. Appeals are by way of rehearing. You cannot make a case and the tribunal tries a case at the lower tribunal based on one or two issues, and you come to the Court of Appeal and you change the game. We all know that consistency is the name of the game when it comes to litigation. Now, we drew attention of the appeal court to this fact that they have changed their case. Their case is no longer nomination and sponsorship, but sponsorship. Today in the judgment, we did not hear anything about nomination. Everything that was said in this court today was about sponsorship. And of course, we know that when you mention sponsorship, it could be pre-election or post-election. But when you talk about nomination, the courts do not have any jurisdiction to entertain it as a post-election matter. And so what we had today is not what we went through at the tribunal. We wait to see the judgment so that we will do the needful. But we thank their lordships for their industry. At least they came up with something. And we also prayed them to release the judgment so that we will study the judgments and come up with our grounds of appeal, because we know that our clients have given us the go-ahead to appeal this judgment. It is sad that a day like this has come, because we know that much as the governor has an opportunity to test this judgment at the Supreme Court, the members of the House of Assembly that are with him cannot go beyond this court. And so the untimely death that they met here cannot be appealed, cannot be tried upstairs. And so it's sad, but we thank God for today. Thank you. I did, under adumbration, say to the court that the tribunal found that there was a repeat Congress. It's a finding, that's number one. And assuming without conceding that there was no structure, you cannot put the cart before the horse. In paragraph 4A of the appellant's reply to second respondent's reply to the petition, they said that the nomination and the sponsorship of the second respondent, that's the governor of Plateau State, is invalid by reason of those court orders. So before you apply the effect of the court orders, you first of all satisfy the court that the issue of nomination is well domiciled in the court, that they have jurisdiction. If they lack jurisdiction to venture into nomination, the effect of the orders, including structure, cannot be had by the court. And that is our position. We did canvass that at the trial tribunal. Before the election, nobody challenged the result of the Congress. Nobody did challenge the result of the Congress. So going into the election, that Congress was hale and hearty. There was no invalidation. So to now challenge it after the election is wrong. It is wrong. So we're saying that Congress was in place and the court found it to be in place.